Well, this year, almost a dozen large Australian companies and government departments have been the subject of significant sexual harassment complaints. In the past 2 weeks, Nine Entertainment and Country Road are the latest whose reputations have undoubtedly suffered as a result of those very public complaints. And just a note, for the record, for almost 17 years, I was inside the Nine News organisation where many of those complaints have emanated. Yet many companies are ignorant of a change in law from earlier this year which puts a positive duty on companies, big and small, to prevent workplace sexual discrimination and sexual harassment from occurring. In other words, it's now law for companies to prevent harassment rather than being able to react to it after it's occurred. Now, to clarify exactly how the new laws work, this week I spoke with Sex Discrimination Commissioner Anna Cody and I asked her for her reaction to these complaints.
I feel really disappointed that our employers and our business communities and across the board aren't doing better. Some of them are historical, so we need to take that into account, but it also makes me realise how much more work we've got to do in this space. We really need to address the endemic issue of sexual harassment and other ways in which women are treated poorly within the workplace, and there are some employers doing a great job and then there are others clearly failing.
Okay, so what companies may fail to recognise is that you have new powers right now, powers of investigation. And so as a result, companies that continue to have these allegations coming up don't perhaps realise that right now that they are in breach of the new laws.
Absolutely. So since the 12th of December last year, we've had a compliance regulatory function at the Commission. So that means that we can inquire into an industry or an employer to find out what they're doing to ensure that sexual harassment, unlawful sex discrimination, sex-based harassment are all eliminated as far as possible. So we've got 7 standards and we will be measuring each employer against those 7 standards to make sure that they're actually changing the culture, educating their workforce, showing leadership and having a really good response mechanism to anyone who's experiencing sexual harassment.
But the important aspect of those new laws is that the onus is not on you to prove it. The onus is now on the employer to prove that they have a safe workplace.
Absolutely. So we have that obligation to inquire into and ensure that those employers are complying with those new laws, but it's the onus on the employer to make sure that it's meeting those 7 standards and adopting an approach that's very much trauma-centred so that the person is at the centre of any response, that it takes into account the breadth of community, whether it be culturally, racially marginalised people, First Nations people, making sure that the response is really tailored to the experience of the complainant.
Okay, so can I take you through some of what I hear as the excuses for this poor behaviour? We've got all of the standards in place, but there's just a few bad apples that are in the bunch. What do you say to that?
Very sadly, it's not just a few bad apples. We know that 1 in 3 people, 1 in 3 women have experienced sexual harassment in the last 5 years. That's not just a few bad apples. We know that it is endemic, sexual harassment, throughout our workforce, and that's why we've got these new laws, because we've recognised as a community that it is endemic, it's a problem, and we need to address it across all workforces. So it's not just a few bad apples.
So to that point, I also will hear, even some women will tell me, well, that's just the way it was going back a few years. Is that a sufficient argument for a company to now mount as you do your investigations?
I think that minimising statement, saying, oh, he's just like that, or we all know that that's what he does, that's a way to try and excuse that really poor and unlawful behaviour. So it's not sufficient for employers to say, oh, it just used to be like that, because we know that it still is like that and that they have a responsibility to ensure that their workplaces are safe for every person who's participating in the workplace.
But you and I both know that just about every company these days has really quite significant human resources programs. So therefore employees are going through these programs, being taught about sexual discrimination and harassment in the workplace, and yet it still happens. Why would that be? And is that potentially one moment at which companies might try and exonerate themselves from the behaviour of some people?
So certainly education and education of workforces and of employers, middle management, senior leadership, boards, All of that is a part of the standards that they have to comply with. But it's not just one-off induction, so that's absolutely a part of it, but ongoing training, and training that's meaningful. So whether that be face-to-face discussions, whether it be online training, all of those things need to be part of a package. Posters up at a workplace, that's a really simple, clear message of this is what sexual harassment is and this is not okay. It's not lawful for you to do this. So that would be a really simple way of educating workforces.
And a person who has been found guilty of sexual harassment in the past, are they a danger to every other workplace that they potentially go into? In other words, is that person in the future unemployable?
I would like to think that people can change, and that once they realise that that behaviour is unacceptable and unlawful, that they can stop doing that behaviour. We know that from other behaviour change type of programs such as drink driving or wearing seatbelts, people's behaviour can change if the community gets behind it. So I would be hopeful that someone's behaviour could change and that they can be employable, but it may be in different types of job or after going through some sort of a education process themselves.
And just one other thing, this week there's been a recommendation from a parliamentary inquiry that this organisation, the Human Rights Commission, be a part of a Human Rights Act into the future. What would that do to change outcomes, in particular in this area?
A Human Rights Act for Australia is long overdue. It is a really great report that's come down from the committee, and we welcome it. The sort of change that it can bring into Australia is that we become much more familiar with human rights concepts, the rights of workers, the rights of people within our community and across the board. So that would mean that we would become more aware of it, and also that there would be ways to ensure that our human rights are respected and are promoted in decision making within government, within businesses and across all areas of our society.
Going back to the issue of sexual harassment, if you do undertake an investigation as per your new powers and laws, when that goes into a court, right now you don't have any case law to basically, sort of, if you like, create decisions or create investigations off. How do you do that, and what are the maximum penalties that companies could be hit with if they fail to comply?
So a complainant always can make a complaint, so an employer is subject to any complainant who brings forward a complaint against them. So that has been a power for some time, and that continues. What's new is that we now have these compliance functions. So our initial response will be to try and work with employers to collaborate to ensure that they meet those standards. But if they don't cooperate and if they don't show us a real progress in the ways in which they're achieving that compliance, then we can seek compliance notices and then enforceable undertakings through the federal court. It's not a penalty-based regime, it is much more a work with us to ensure that you meet those standards.
Would a penalty-based system be perhaps more effective in some ways?
That's not the approach that we have sought, because a complainant, if there's an award of money or a settlement, then that generally is some sort of penalty against, or it's a recognition of the harm that that an employer has caused to an employee. But a regulatory approach, the modern approach, is to ensure voluntary compliance so that we get a breadth of compliance across all industries.
And just a final one, we've talked broadly about larger companies that have the resources to put the programs into place to try and seek the change. But this must also be endemic, as you say, 1 in 3 workers having felt that they've been harassed. That's also saying that small and medium-sized business, that must be also endemic in that type of area.
Absolutely. And what we're hearing, we're doing consultations at the moment across all states and territories, and what we're hearing is that small and medium-sized businesses have a particular issue, and we're very much focused on ensuring that all businesses recognise that new responsibility. We've got fact sheets which give information so that they can inform themselves, particularly what their responsibilities are under the new positive duty.
Anna Cody, good to chat to you today. Many thanks for your time.
Thanks very much, Ross.